Okay, we are back and we are still in the introductory materials talking about how laws are made. I've now moved on to the handout material that is in the notes called Note 1. Has to do with law and legal reasoning. A little bit of this covers what we've already spoken about in the video just prior to this, but I want to go through it quickly again. So, again, looking at those notes, I have a listing of the sources of American law. First and foremost, we have what's called case law, or the modern day equivalent of the English common law, prior court decisions, due to the theory of precedent, have the force of law. And when the court hands down a decision, lawyers and business people know that this law is probably going to stay the same. This ruling is going to stay the same for some time because the idea of precedence says that the court cannot go willy nilly deciding an issue one way one year and then changing their mind and deciding it differently the next year. This theory and its application, which is not anywhere in the Constitution. The Constitution doesn't speak about this at all, but this idea was so much a part of English law that even though it wasn't in the Constitution, it was being utilized by the courts of the former colonies when the constitutional government was created, and it was just picked up and followed as this is the way things are done. That had been such a part of English law for so many centuries that nobody even questioned that that's what should happen. Now, because of this, our Supreme Court has taken on an extreme amount of power that courts in many countries do not have. Because two things. One is very early on, as we said in the last video, in a case called Marbury versus Madison, the court made a decision and handed down a ruling that said if there's ever an issue about the interpretation of a statute, of anything that Congress has created, what does it mean? How is it supposed to affect people? Does it meet muster with the Constitution or not? That it is the job of the Supreme Court to decide that. That has been expanded to give them power to decide activities of the president, activities of the executive branch. So basically, at this point, our Supreme Court sits and has taken onto itself the ability to tell the other two branches, no, you can't do this or you can't do that. That statute is unconstitutional. That action, that executive order signed by the president can't stand. And so it gives the court a supreme amount of power. And once they make a decision, particularly when they're making a decision based on a constitutional principle, because they are the highest court of appeal, you can go no higher. Our court system does not generally recognize the World Court in The Hague. It doesn't recognize the different United Nations tribunals as having any jurisdiction over our system. So once a case goes to the Supreme Court, and a decision is handed down, a constitutional provision is stated, then all the other courts, all the state legislatures, the Congress, the president, the governors, all the heads of the different bureaucratic departments, they know that this is the law and it is not going to change quickly. That once the Supreme Court has decided it, it is done. Gives our court, as I said, authority that the courts in most other countries do not have. Case law is merely what we call today those prior judicial decisions that become law. In England, in the old days, it was called common law. Statutory law is law created by your representatives, either by your state legislature or by Congress, the people that you vote for, that you send there on your behalf. We do not technically have a democracy. We have what is called a republic. In a democracy, such as they had in ancient Athens, every citizen, every eligible voter got to vote on every law, on every rule, on every change. The writers of our Constitution realized that that would be unworkable and unwieldy, and particularly in the late 1700s, where it took sometimes 4 or 5 weeks by road and a week by ship to get from New York to Washington or from New York to Charlestown. That democracy would not work. Plus, the writers of the Constitution tended to be from the business classes, from the upper classes. They were somewhat afraid of giving the public free rein, of giving every single male person the power to decide what was going to happen. So in our system as a republic, we vote for people to represent us, and those folks are the ones who then get together and by majority rule make the laws, make the statutes. We get to vote indirectly for the executive who carries out those laws, but the average person does not have a say in every single item on every single word that's going to go into legislation or going to go into the laws. Today, many of the laws have been compiled and put together by think tanks and law professors and associations of lawyers, and the statutory law has, as part of it now, a number of uniform codes. A code is where we look at a whole area of law and say, hey, we're going to try and write the rules from beginning to end in a coherent order. We're going to try and cover everything, which is not the way that legislatures acted at the time the country was set up. Rhode Island still has very few codes, and our legislature will pass laws kind of willy-nilly. We'll change a little here, a little there, add something to this, take something away from that. That's permissible. That happens, I think, in Congress. It happens in all states. But in order to try and make things uniform across the 50 states, beginning with the Uniform Commercial Code in the late 1950s, early 1960s, different think tanks and lawyers groups began to draw up coherent sets of laws and to push the state legislatures to adopt them. So there are now uniform probate laws, the Uniform Gift to Minors Act, the Uniform Commercial Code. There are a whole series of uniform laws that attempt, particularly in the business world, to try and keep things so that if you're dealing in Rhode Island with a company in California, but you have to warehouse your stuff in Arizona, the law of all those three states is basically consistent. So you will run into that. You will run into some people calling statutes codes, and you will run into that people calling them uniform law. In addition to statutes passed directly by Congress, today, beginning probably at the turn of the last century, in the early 1900s, Congress began delegating authority, creating federal agencies like the Food and Drug Administration, like the Centers for Disease Control that we've heard from so much during recent months, like the IRS, like Immigration Services, Health and Human Services, the Department of Education. Congress would set up these organizations to carry out basic laws that Congress had passed or to spend money they had allocated, but then they would also give these agencies something called rule-making authority. So Congress will say, it is our goal to have every child in the United States be able to do math at a 12th grade level and to be able to read and write at a 12th grade level before they receive a high school diploma. That's the basic law. The Congress will then give the Department of Education the power to create rules to implement that law, and the rules will very often be tied into money available to help carry out the law, and of course the states will be bribed into following the rules and accepting the law by wanting the money. So just know that very much of what a lawyer does today in many instances doesn't even get to the level of court cases or to statutory law, but it is administrative law. You're dealing with a bureaucrat who has a set of rules for his or her agency sitting on their computer, and you're arguing with how those particular rules apply to your client or your client's situation. And then, of course, on top of all this in our system, wrapping it all together, is constitutional law. The Constitution created the federal government. It created our individual rights, or it recognized our individual rights in the Bill of Rights, and it becomes the bottom line framework from which everything else is judged. In order for any law, statute, regulation, presidential order to be valid, it must meet constitutional muster. Now, not everything ends up argued in the courts. Not every rule or regulation ends up having a court hearing because there is a presumption. And for those of you who haven't had me before, a presumption is something that the law deems to be true until you bring in evidence to prove it otherwise. And there is a basic presumption in American law that a statute, an act of the president, is constitutional until a competent court rules it otherwise. And the competent court would mean for president and the Congress, it would have to be one of the federal courts and ultimately the Supreme Court. The state courts do not have particularly large powers to tell the president or tell a federal agency that they're acting unconstitutionally. Okay, now let's talk a little bit about law and case law and how that operates and some of the different ideas that float along. In the English system, there were two sets of law. There was the law, which is the basic, what lawyers call black letter rules. You shall do this, you shall not do that. Murder is, ba 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 ba. Burglary, one of my favorite ones, is the breaking and entering into the dwelling house of another at night with the intent to commit a felony therein. Basic, this is what the law says, this is it, and the court has very little power to change that, amend that, at least the lower courts. They must just apply it. In the English system, particularly when we were on the criminal side and even on the civil side with penalties and cases, the law could be very severe, very strict, and if you missed one little letter, one little thing, your case was gone. On the other side, the English courts had a separate court, originated in the church courts, but then when Henry VIII became head of the church in England, he made these part of the civil courts, but for many years, right up into the founding of the United States, they stayed as separate courtrooms, separate sides of the court, something called equity. And equity is the idea that there are certain principles of fairness, of justice, of fair play, of looking for the correct situation where sometimes the technicalities of the law may produce injustice. And so in the English system and in the early American system, you could plead your case on the law side, and if you lost, then you could go to the equity side and say, Your Honor, we lost on a technicality, but the result of that is hideous things are going to happen based on this technicality. Equity must come in and make sure that justice happens. Today, these two systems have been merged, but the rules still exist. And when a lawyer sets up a case to go to court, particularly a criminal case, in civil case, in criminal cases, equity comes into play more in sentencing and imposing fines and whatever, but in civil cases, equity is always available. The lawyer will first set up the legal case and in his complaint say, Your Honors, this is why my client should win. Here are all the black letter rules, here are all the laws, all the regulations. But then in the alternative, in the same complaint will plead, however, if you don't like all of that, Your Honors, here are the fair and just and merciful rules why you should have my client win, even if you don't like our case under the black letter substantive law. So just be aware that there are two ways of looking at this, and at least when I was in law school, they were still taught us two different things. We had separate courses in equity and then separate courses in legal damages. And one of the biggest differences today is in the way that damages are awarded. On the law side, we try to always take damages and turn them into dollars, and that your compensation is to get money. On the equity side, is the side where you may have the court entering injunctions or ordering people to do things because money would be not sufficient, wouldn't provide justice in a case, and the court has to order things to change or order certain parties to take actions in order to bring justice about. Precedent in stare decisis, as we've talked about, is still applied. Usually only appellate courts and the highest court in any state or the Supreme Court on the federal level have absolute precedent value. So a lower court decision is important for that particular case, but it's not necessarily precedent in another case that comes up on the same type of facts, unless the first case subsequently gets appealed and then at some point an appellate court or a Supreme Court rules upon it. One of the things you need to know as we're talking about laws, and we're talking particularly about courts, every court case is a dispute. Every court case is an argument. Even a criminal case is a dispute. The state is saying, you did something so bad, we're going to fine you or we're going to put you in jail. And the defendant is saying, no, I didn't. I'm not going to submit to that. Or even if I did it, I don't have to submit to that. So at the core of every case, there is an argument, there is a dispute, there is an issue to be resolved. All right. Um, when particularly you're doing your briefs, and not just here, but as you go forward, judges and lawyers like me love to talk ad infinitum, which means forever. We can go on and on and on, and unfortunately today, many judicial decisions go on for 30, 40, 50, 60, 100 pages. And you can just die trying to wade through it and figure out what in God's name are they talking about. The judges, seem from the lowest levels right up to the Supreme Court, seem to feel that by having become a judge, God has given them the right to pontificate about anything and everything incessantly. And then we poor lawyers and citizens have to try and read through all this to find out what's going on. So particularly when you're briefing cases, the most important thing to keep in mind is early on, look at the facts, see what's happening, and try and figure out what is the dispute. What is the argument? What are they really disagreeing about here? And then as you go through a decision, see how the court answers that. And a lot of times, a lot of the decision is not an answer. It's just kind of a meandering path of, well, we could look at this, we could look at that, or we first thought that might apply, but now we've decided this didn't apply, and eventually they get to an answer. Which is one of the reasons why briefing is so important. And why lawyers who particularly are trial lawyers have a very busy, high-powered schedule, little time to prepare, will use other lawyers and paralegals to brief because they don't want to read the 200 pages of fluff. They want to get to the core of the decision. What was the answer to the question? There is actually a legal rule that says the only binding thing in a case, the only precedent, is the actual legal decision, the language of the legal decision, and everything else. The lawyers have a slang for it. We call it dicta, and dicta is just like in a dictation machine, which I guess you guys may not know about those either, but dicta is just a fancy Latin word for saying talking on and on. And one of the things that young lawyers and law students and paralegals get tripped up on early on is that, again, very often a case will have wonderful dicta. A judge will go off on a tangent and write wonderful things about, wow, the law really should say this and say that and say this and say that. If that is not answering the question in the case, it has no value as precedent. And if you quote it in a brief, if you quote it in a memorandum, and somebody actually reads the case and realizes, they come back to you and say, well, that's all wonderful, but that's just a fairy tale for this matter. It doesn't apply. Okay. Judicial review, again, is this idea established in Marbury versus Madison by the early Supreme Court, saying that they have the right to tell Congress, they have the right to tell the president what is constitutional, not constitutional, and thereby they maintain a fair deal of control over the activities of those other bodies, and probably more control than the writers of the Constitution actually originally intended. But that system was called into being very early on in the existence of the government, and the power of the court in that respect has only grown over time. Okay, there are a number of schools of legal thought, and I've just thrown in, again, we're getting to the end of note one. There are different ideas, and these are certainly not all of them, but to break down into some of the ones that are being discussed today. Many people follow something called the natural law. And the natural law is the idea that just as math exists and 2 plus 2 equals 4, and just as water is made up of elements, two hydrogen and oxygen atoms, and that we can find this out and we can discover it, and because it is built into the structure of nature, that's the way things are. Natural law is this idea that all law, all of our rights are divined or pulled out of or found in, derived from the workings of the universe. That there's this code written into the universe that can be applied, and theoretically should be able to be applied everywhere, in every country, every place, every state, every town, because it would be the same rules that are being applied. It's like the idea of gravity. Gravity applies everywhere on the planet, so far as I know. Um, this often has a religious basis because many aspects of religious laws are generated from this idea of natural law. The positivist school looks as laws as only as rules, only as agreements between people. We are all driving our cars around willy nilly. We're getting into accidents and killing each other. So, therefore, we will put up these things called traffic signals with red, yellow, and green lights. And we will establish a rule that says on red, you stop. On yellow, you proceed cautiously. And on green, you can go. And if you violate that rule and you injure somebody or damage their property, you can be held criminally liable. You can be held civilly responsible for their injuries. Um, a positivistic type of theory would say there is no higher reasoning, there are no universal rules, that people just get together and societies make the rules that they want to have in place. And of course, as society changes, as ideas change, as people change, those rules should be freely able to change along with the will of the society, of the people. A historical school tries to look back, and in constitutional learn, in trying to determine what the Constitution means, this is a very powerful school, mostly a conservative school, where the justices say, well, if the founders, if the writers of the Constitution had been presented with this problem, how would they have solved it? And our society has evolved, our technology has evolved in such a way that there are many things that go on today, many things for which laws are enacted that the founders of the Constitution would have had no clue about. They had no idea, it didn't exist in their time. But the historical school attempts to go back and look and to see, all right, the people who wrote these documents, how would they have handled this? Let's see if we can extrapolate some of their theories, their ideas into the modern situation, and that our job is to preserve what had been handed down to us by the way of the Constitution and only look to change it by means of the amendment process that is built into it. Amendments to the Constitution happen very rarely because they are very difficult. It takes a majority of the supermajority of the Congress. It takes the president. It takes a supermajority of the states. And needless to say, particularly in present times, we are not in agreement enough to ever get that type of change done. But a historical school legal theorist would say the only way to change the basic constitutional law is through that process. And legal realism is an idea that says, yes, we have to look at the law, we have to look at the tradition, we have to look at this here, but we also have to allow it to bend and to move, to deal with new situations, and we do not necessarily are bound by nature or by what's happened in the past. Um, Strict construction, those are judges that believe in applying the Constitution only as it's written and not extrapolating, not extending it. Judicial activists are judges that believe the Constitution is a basic framework, a basic guiding principle, but it certainly didn't tell us anything about how to regulate nuclear energy and therefore, or run electrical systems or automobiles or airplanes, and so therefore the law must change and evolve to meet the political and the social conditions of the present times. All right. The law is broken down into different categories, and some of those categories are substantive law versus procedural law. The substantive law is the actual rules and regulations, the things that must be done or can't be done. Procedural law is how do we do things? How do we get there? In court, in particular, procedure, or in a hearing before an administrative body even, procedure is as important as substance. The procedure tells you, how do I file this paper? What do I have to put in it? How do I argue before the court? How many days do I have to answer this? Both types of law are required. One of the reasons that even lay people who are not lawyers, they study up on the law, they think they can represent themselves in the judicial system, they maybe have an excellent understanding of the law as it applies to this situation, but the procedural rules and the procedural practices would drive anyone crazy. They're complicated, they're not particularly logical at times, and without knowing them, you're not going to be able to work your way through the system. So when a lawyer looks at a case, there are two elements that are always looked at. One is what's the substantive law, what's the rules, what's the legal theory we're dealing with, and then what's the procedure? How do we get from here to there? How do we get before a judge? How do we file an appeal? How do we get evidence in to prove our case? The law is also divided into two great divides, the civil law and the criminal law. The civil law is basically there to govern the transactions of private parties and they're dealing with each other, and the states and the federal government are considered parties also. The criminal law is there to punish certain behavior that the society has decided is so repugnant, so abhorrent, that we will punish you. We will use the force available to the government through fines, through jail, through other types of penalties to punish you and to hopefully keep other people from violating these rules. All right, that finishes note 1. I want to just quickly, before we end this section, go over the handout called Property Rights and Economic Control in the Constitution. Again, I think most modern people think of constitutional rights of having to do with our civil liberties and our personal rights, but the document was written by people of means, written by men who were merchants, who were plantation owners, who were business people, who were lawyers and politicians, and they were greatly concerned with private property and with how much control or how little control this new government would have over their property rights. So, basically, in Article 1, which controls the creation of the Congress and lays out the powers of the Congress, they give tremendous economic power to Congress. Right? Congress has the power to raise revenue through taxes. They can collect customs duties, excises. They can issue currency. They may borrow money, which we have been doing with a vengeance for the last 40 years. They can regulate commerce with foreign nations, among the different states, and with the Aboriginal tribes. They can fix the value of money. They can set the amounts for weights and measures. They can punish counterfeiting. Congress, right in the Constitution, was given the power to establish post roads and post offices, to set up a mail system, which they realized was incredibly important, to have some organized, unified system to move information back and forth. The Postal Service, although it barely looks like it today, was the original paper internet. It was the way to get ideas and goods and services and money moving back and forth, up and down the country and between people. And the Constitution gives the power to control that and regulate that to Congress. Most importantly, for the development of the economy and for the development of our society and our technology, from the very beginning, Congress was given the right to give copyrights, trademarks, and patents to individuals. So that if you came up with an industrial process, you came up with an idea, you wrote a song, you wrote a poem, you published a book, you owned it, and if other people wanted to use it, you had the right to demand that they pay you for it. One of the reasons that technology developed so fast and so extensively in the United States is that once people around the world realized that we had this protection in our system, inventors and people from all around the planet came here to take advantage of this power. Congress controls bankruptcy. Bankruptcy is the idea that people can get themselves so far in debt that they would never get out of it. In England, they handled that by throwing you in jail and hoping that you had a rich aunt or a rich uncle or a grandmother who felt bad for you and come and pay your debts and get you out. A number of the colonists, grandparents, great-grandparents, ended up in America because they couldn't pay their debts in England, and one way to get out of jail, to keep from going to jail, was to sell yourself as an indentured servant, where you would sign up to work for somebody for free for 6 or 7 or 10 years. They would pay your passage to America, you'd put in your years of hard labor for them, and then eventually you'd be freed, and they would also have paid off your debts in England at the same time. So bankruptcy is the idea that some people will need a chance, and I have had clients who need several chances in their life to wipe out their debts, to be able to start again. The bankruptcy code actually calls it having a clean slate. A slate being the little tablet that colonial children used to write their lessons on. And of course, when you finished one lesson, to do the next one, you had to wipe it down and clean it off. The Constitution said that Congress could not impose a direct tax on individuals. And that stood for a very long time, from the 1790s until 1913, when the 16th Amendment was passed, and finally that created the income tax as we now know it and allowed Congress to directly tax individuals. The income tax has now been supplemented by a Social Security tax and by a Medicaid tax, Medicaid tax, so that individuals since the early 1900s have had the federal government every pay period sticking its hand into their pockets. That was something that never happened in the 100 and some years of the Constitution of the government prior to that. No state may impair the obligation of contracts. Again, written into the Constitution, and what that does is it's basically saying that contracts, agreements between individuals for the buying and selling of goods and services are sacrosanct, and the states and Congress cannot abrogate them. They can't play games with them. They have to honor them and legally protect them. Again, made the business climate here much more stable, much safer than it was in large parts of the world in the days when the Constitution was first written. The Fifth Amendment says that property cannot be taken without just compensation. Eminent domain is the idea that the government can take your property because they need it to build a school, to build a military base, for whatever purposes. But the Fifth Amendment makes it very clear that the government cannot do that without paying you fair market value. The Fifth Amendment and then the 14th Amendment goes on to say that no state nor the federal government may deprive you of life, liberty, or your property without due process of law. So that there possibly could be a system where if you're growing illegal marijuana in your basement, there could be a seizure of your property, but there must be a legal process. There must be due process. There must be notice and the opportunity to be heard to argue your case while your property or your life or your liberty should not be taken. All right, that ends this session. I'll be moving on to notes number 2, and that's going to start getting us into the actual business organization materials of the course. So follow up with that. Be good.